involvement of social services. There is clearly a greater level of harm because there is a death. The Sentencing Council guideline for cruelty to a child applies to count 2. Neglect is reflected as part of the duration of the conduct relevant to the sentence for gross negligence manslaughter. I agree with the submission that if looked at alone, neglect that did not cause death would be a Category 2C offence with a start point of 12 months and a range of sentence between a community order and 2 years, 6 months imprisonment. The neglect was both to avoid the involvement of social services and follow the previous lack of care towards your other children. There are some aggravating features leading to a sentence for the offence, if being considered alone, that might suggest it comes towards the top of the range. There is no real mitigation other than the lack of previous convictions in your case, Martin, but that must be viewed again in the context of the earlier care proceedings. Turning next to reports and references. Mr. Gordon, in your case, the pre-sentence report is dated the 11th of September this year. It is compiled by a very experienced probation officer. I express my thanks to her for her analysis. I note what she says about the way in which you were guarded and evasive, frequently deflected direct questions when interviewed. I note what is said about your account of the facts. I note that when you were asked about the dynamics of your relationship with Martin, you said you couldn't answer as you were concerned about information being taken the wrong way. I note also what you say about the future of relationship between you and Martin. In terms of my assessment of the issue of dangerousness, as well as what is set out in the report as to future risks, I have the advantage of seeing you through the trial, the retrial, and I'm also aware of the issues in the family court as well. I have seen and read a sentencing note prepared by counsel recently instructed on your behalf. Today, a 34-page psychiatric report from Dr. Farnham was provided. In his detailed report, he sets out a history from you, the observations he made when he examined you on the 9th of September, and then passages from the pre-sentence report dealing with dangerousness and risks. He also comments on a letter from Dr. Hillier, where there was a possibility of an adjournment to the sentencing hearing. As I've made clear in this hearing, that application for an adjournment was not made. I've considered what is set out in the summary and opinion section of that report. I've reflected on Dr. Farnham's observations in relation to dangerousness. As he states, the question of whether the test is met is one for the court. I also note what Dr. Farnham says about Dr. Hillier's letter. He makes some observations about the nature of self-reporting. It doesn't appear that Dr. Farnham has seen the reports from Dr. Hillier, but in my judgment, there is a real risk of reports at this stage of a protracted case being largely the result of self-reported symptoms. A further report of Dr. Robert Hounsey, a psychologist, dated the 12th of September, was provided to me after this hearing had started. That report sets out the history that he was provided with, some psychometric tests, followed by his opinion, including his observations on the dangerousness test. On your behalf, Ms. McAtanzi, KC, adopts the position on the facts set out by Mr. Godfrey on hypothermia or smothering. I have already made clear my conclusion earlier in these remarks on that issue. She's also reminded the court of matters that you set out in your evidence to the jury. Whilst I've had regard to what you said in evidence, the weight to be given to your evidence is limited as a result of the failure for you to be cross-examined upon it. On the guidelines, it is submitted on your behalf that this is not a Category A case, and the court invited to exercise caution as to the Category B features and the need to ensure that there is no double counting. Again, on this issue, I've made clear my conclusions. On dangerousness, Ms. McAtanzi submits that the high test is not met. She submits that all the professionals are of the view that you should not be regarded as dangerous. While she accepts this is a matter for the court, she points to the age of your antecedents when you were a child, a period you spent in prison during your formative years. As she observes, Dr. Farnham makes a number of points as to what happened to you in those years and the impact on you. In terms of personal mitigation, reference is made again to the reports and the impact on you of your other children being taken from you. You say that you regret poor decisions were made and how things happen. You have said that you will have to live with the consequences of what it is and what happened for the rest of your life. It is said that you were not then thinking rationally and properly, and your whole life has simply imploded. In your case, Miss Marten, the pre-sentence report, also dated the 11th September, it too has been compiled by an experienced probation officer. There is a very detailed account from you to the author of the report on the facts and of your own background. Again, I express my thanks to the author for her helpful analysis. On finances, I note you told the probation officer that you believe you will have access to the discretionary trust in the future and that restrictions on access may fall away when you turn the age of 40. You also mention another separate trust that you will have access to. There is a lengthy section of the report dealing with relationships, both within your family and with Gordon. I do not intend to repeat here what is set out in the report as to your observations on those relationships. As I've said about other aspects of the case, in my view, some of your observations and counts are simply not reliable. A number of letters of reference have been provided. One is from your stepfather, Guy de Celliers, and another from your mother, Virginia de Celliers. There are also letters from Macusa Robert, Cecilia Rabayo, and Sophia Fellows. I have read all those letters. Those authors speak warmly and lovingly of you. There is a psychiatric report from Dr. Bradley Hillier that was sent to me last Saturday. It refers back to a report he prepared in the course of the first trial. At that time, Ms. Marten, you were not prepared to be seen by the prosecution psychiatrist, and so the report of Dr. Hillier then was not relied upon. His report now is largely based on what you've told him. I note in the summary of his conclusions that he says you were experiencing a mild depressive episode within the context of recurrent depressive disorder at the time of his assessment. He also says that you continue to meet the diagnostic criteria for complex post-traumatic stress disorder. He does not consider you meet the diagnostic criteria for any personality disorder, nor does he consider there to be a diagnosis of substance use disorder. He says that you would benefit from an assessment of your sleep function by an appropriate expert. He also says it's very likely that your CPTSD was present during the period of the alleged offences and triggered by the death of the baby. He also says that your reported behaviour following the death of the baby would not be inconsistent with a process of grief complicated by trauma. My attention has been drawn to the guidelines on sentencing those with mental disorders. I need to consider what is set out by Dr. Hillier. As the guidelines make clear, the fact that someone has any impairment or disorder should always be considered, but will not also always necessarily have an impact on sentencing. Each case will be different and require its own consideration. In some cases and situations, culpability may be reduced. In my judgment, that does not apply here. I have no doubt that the fact your other children being taken from you is a significant matter and had an impact on you, but it needs to be seen alongside your actions in 2022 and 2023 and your reasons for acting as you did. Dr. Hillier addresses dangerousness and expresses his observations. The issue is one for determination by me. I've considered the analysis of the issue of dangerousness in the pre-sentence report and in Dr. Hillier's report, and reflected on all the other details I have, including from the family court proceedings. The bar for the test to apply is a high one, and in your case I do not find it to be met, and there will not be a finding of dangerousness in relation to you. Today a further short report of Dr. Hillier has been provided to me. Again, I've read and taken on board what he has said. I've made mention of the sentencing note prepared by Mr. Godfrey and Mr. Trefgarne. A supplementary sentencing note also being provided to me following on from those reports. Again, I'm grateful for the observations made as to the factual basis of sentence, the approach to guidelines, and how I should approach the reports. The mechanics of death, Mr. Godfrey invites the court to accept the evidence you gave about it. He relies on what you were to say in interview as well as what you said in court. I've dealt in some length with my factual conclusions for the reasons that I've set out above. On the date of death, I've made clear that I have accepted it was by the 12th of January. On sentence overall, Mr. Godfrey submits there has been remorse and sorrow expressed by you. He submits that from early on you've accepted the baby died as a result of something you did. He submits in your case that your remorse is genuine. Well, I have already made my observations on that topic already. Sentence. On gross negligence manslaughter, in your case, Mark Gordon, there will be an extended sentence of imprisonment amounting to 18 years, with a custodial term of 14 years and an extension period of 4 years. In my judgment, Gordon, in your case, the dangerousness test is met. I've given consideration to the provisions of Section 285 of the Sentencing Act 2020 and whether the seriousness of the offence or the offence or one or more of the other offences associated with it was such as to justify the imposition of a sentence of imprisonment for life. However, I do not find it to be. There will be the extended sentence that I've passed upon you. Martin, in your case, as the dangerousness test is not met, there will be a determinate sentence, a sentence of 14 years imprisonment. In your case, I've given consideration as to whether the custodial sentence should be of the same length as that passed in respect of Mark Gordon or not. Having reflected on the issue, I am of view that the custodial terms should be of the same length. The issues around future risks have led me to the conclusion that Mark Gordon should be the subject of an extended sentence, and there is therefore that distinction between the two of you. On count 1, concealing the birth, the sentence in each of your cases are ones of 18 months imprisonment. Count 2, child neglect, the sentence in each of your cases again ones of 18 months imprisonment. On count 5, perverting the course of public justice, the sentence in each of your cases are ones of 5 years imprisonment. The sentences on counts 1, 2 and 5 are to be concurrent to each other and concurrent to the sentences on count 4. Gordon, in your case, what that means is it's likely you will serve 2/3 of that custodial term that I've imposed. If released at the end of that custodial term or at the 2/3 point, you will be on licence until the expiry of the extended period of licence in your case. Martin, in your case, you will serve 2/3 of the sentence I've imposed and then be released on licence. Released on licence, you are subject to the terms of that until the expiry of the custodial term. As the statutory surcharge clearly applies here, the appropriate orders can be drawn up. Before I leave this case, this was clearly a difficult and painstaking investigation for which many police officers were involved. I express my sincere thanks to all of those involved. Inevitably, some officers will have undertaken a significant amount of work to bring a case of this nature to court and to a conclusion. And I would particularly wish to commend Ian Valentine, Martha Bourne and Leanne Cowdery for their commitment and work on this case.